Welcome to this very important conversation on redundancy. My name is Stella Wangui Muraguri. I'm the managing partner at MMW Advocates LLP, which is one of Kenya's largest female-led law firms. With me, I have my colleague, Ian Nchoga, who's a deputy managing partner and the HR lead in the organization, as well as George Laichena, who's equally a lawyer in the dispute resolution department. Now, at MMW, we are known for embracing and solving the complex. And it's important that we explain that the law firm that's presenting to you today is not only known for employment matters, we also have a real estate department, which helps with land transactions. We have a commercial department that helps you with structuring of deals and reviewing contracts, such as HR contracts, by the way. We have a debt recovery department that collects debts on behalf of our clients at no cost or no upfront cost. And then we have a litigation and dispute resolution department that helps with in and out of court disputes. We've been recognized locally and internationally for our legal excellence. We've been deemed as Kenya's top 100 commercial law firm, and last year we were SME Law Firm of the Year, among others. But today our job is simple, ladies and gentlemen. It is simply to unpack redundancy, simplify it for you, so that then whenever you are either dealing with it, faced with it, or you're a HR practitioner and you're consistently having to have redundancy conversations, you're not just guided by a HR manual, but you're guided by the law. And then we are able to breathe life into what the Employment Act and precedent states. It's also very important to state that you cannot read the Employment Act in isolation with what the courts have decided those particular provisions mean. And let's be honest, redundancy has become the go-to tool for exits and for terminations. But when done wrong, it can end up costing an employer not only time in court and a bad reputation, because these days we have employees who actually go to law websites to just look, does this company have a good or bad reputation when it comes to employee terminations? But also it ends up costing you a lot and leaving you blindsided. So whether you're an employer who's navigating the question of redundancy, then how do we demystify this to you? How do we bring it to life? And how do we also make it an exciting process and not a daunting process? So to start it off, we must then look at what has redundancy look like, just in terms of a clear picture in Kenya. If we could go to the next slide. In 2024, and this is such a daunting statistic, it's almost scary, over 202 companies, and I just want that to sink in, 202 companies declared employees redundant. And these are just some of the examples that we're able to see. Standard Group, which was a mainstay company when we were growing up, declared over 300 employees redundant. More University, 900 employees redundant. G4S and KK Security, again, such strong institutions, declared over 1,500 employees redundant. Posta Kenya, again, a company that we grew up using, over 600 employees redundant. And the number goes on and on. And it's just not a local problem, by the way. It's not a local problem. It is also an international problem, because even companies such as Microsoft, due to how processes are being automated, due to AI, rendered 16,000 employees redundant. So then this tells us that this is just not a unique problem for other companies. It is a problem that can be actually at your doorstep, and you need to have the tools on how to deal with it. Those statistics now being shared, the question that we have before us is, what is redundancy? And once we understand this particular definition on what is redundancy, once we understand that definition, it becomes that much easier for us to deal with it, because you know what it is and what it is not. So to give this context, it is important for us to go through a narrative or a storyline that we have created. So this is our narrative. You can choose to look at yourself as Mary. You can choose to look at yourself as the HR at Maziwa Limited. So Mary has worked as a packaging technician at Maziwa Limited, a dairy products company, for the past 10 years. Okay, so she's given the company quite some number of years, and she's now earning a monthly salary of 60,000 shillings. So each day she manually filled, sealed, and labeled 500 packets of milk, contributing consistently to the company's operation. So every day she's sealing 500 packets of milk. However, the company ended up buying an empty packer machine, which now automates what Mary used to do and does the 500 she was doing in a day is now done in 1 hour or under just 1 hour. And as a result of this upgrade, Mary is called by her HR and GM, and she's told that her position has been terminated. The company tells her that they will give her 1 month notice, her leave days, which is 28 leave days that she had accrued, 10 days she had worked, assuming she was being terminated on the 10th of that particular month, and a send-off package of 100,000 bob and a farewell party. Is this situation familiar? And the question now we ask ourselves is, as we look at this particular narrative, were there reasons to let Mary go? Is this a redundancy or is it a normal termination? Because whilst redundancy is a way of separating the employer from the employee, it is not just like any other termination. But how was it handled? By calling her to the office, was that a fair process? By giving her this loyalty bonus of 100,000, was that all that was due to her? So, in the course of this particular presentation, we shall go referencing to this matter of Mary and Maziwa Limited, how it was handled, were there genuine reasons. That is fall under redundancy. So then, with this as the background, the question that we have in front of us is, what is redundancy? And if you have any questions, by the way, feel free to ask them on the chat in the Q&A section. We shall handle them at the very end. So redundancy is when someone loses their job because the company does not need that particular service or position anymore. And I just want that to sink in as well. So meaning, at the time you're letting this employee go, it is not on the basis of they did something wrong. It is not on the ground that they did something wrong. It is simply, just a second, it is not because they did something wrong. It is involuntary. It is a process that is initiated by the employer, and it is at no fault of the employee. And that is very important for me to emphasize. It is at no fault of the employee, meaning we are not saying that their capacity is in question, their conduct is in question. It is simply at no fault of the employee. And it's also important to then distinguish, it is that the position and the service is no longer needed or it's no longer relevant. So it should not be a way of targeting an employee, and there must be genuine reasons behind it. And the law and courts have stated that there must be good reasons, fair reasons, reasonable reasons, and in good faith at the point within which you're actually letting an employee go. Now, think of it this way. If you're saying it's not about the person, it's about the job. That is, the job is no longer making sense. So in Mary's situation, it was not necessarily, please go back to the previous slide. Yes, thank you. It is not necessarily that Mary did anything wrong. It was not that she had any gross misconduct. It's just that it made sense for the company to get a machine that makes it competitive in the market. That's about it. Now, if then we have to simplify that, if we may go to the next slide. So redundancy is therefore not firing someone for poor performance. Okay, it is not a disciplinary issue. And it is therefore not also a shortcut to avoid lawful termination. And remember, I said the word, it is not a shortcut before, because I've also had employers who've come to me and said that they want to get rid of an employee, but they don't want to really fight with that particular employee. So they want to go the redundancy way. But the moment you do that, you're setting yourself up for failure, because then when you hire another Mary, if, for instance, another Mary is hired 2 months down the line, then that employee can easily go back to court and say that my position was not rendered redundant. And therefore, they ought to reinstate me. because reinstatement is also something that can come up. So if you need to go through lawful termination, just go through lawful termination, but do not make a position that was not meant to be redundant because you just want to have a shortcut way of avoiding a court process. It might end up costing you more in the future. So what have the courts, what is, okay. We seem to be having a technological issue when it comes to the question of slides. Apologies for that. So what have the courts stated on redundancy? In Jen Kalachi versus Oxford University, the court has stated that it should be the position that is rendered redundant and not the employees. I have stated that over and over again. I will not recount it. It should be no wrongdoing of the employee. At no point should you say that we let this employee go because they were not performing well. That is not redundancy. It should also be in good faith. We stated that. And compliance is mandatory. It's not discretionary. And allow me to just emphasize on compliance is mandatory. A lot of employers also have found themselves thinking that they will comply with certain parts and not certain parts. It is not up to you to choose what to comply with as an employer and choose not what to comply with. The entire process of rendering an employee redundant is mandatory. And you can actually then end up paying compensation on account of lack of compliance. So look at it this way. What does the statute say? What does the law say? That is your bare minimum. That's how you should look at it. So what does the law look at in that case? The law looks at, number one, there must be substantive justification. And this sounds like a big word, and it may sound a bit of like jargon, but substantive justification basically broken down means there must be justifiable reason. Why am I actually rendering this employee redundant? You remember, we said it must be fair, reasonable, good faith, genuine. There must be genuine reasons. Just like in Mary's case, there must be genuine reasons. So the justification must have real substance. That's the word substantive justification. And then procedural fairness. It should be fair in how the procedure that you actually undertake in rendering the employee redundant should be fair. And fair is actually as defined by law and not as defined by your subjective version of what fair means. So to take us through the next step, Ian will walk us through substantive justification. Now, Ian, in Mary's case, was there substantive justification in actually terminating her or rendering her redundant?
Are you able to hear? Okay. All right. Yeah. It's all the chat. Okay. All right. Okay. Apologies for that. I think I've been able to Okay, all right. Apologies for that. Thank you for your patience. I was just sorting out a small technological issue. So allow me to just pick it up from where Stella had left. So as she had said, substantive justification seems like a very complex word, particularly if you have not been in the legal space or you have not interacted with redundancy before. But it is very important to understand because this is one of the main reasons that courts will always look at to determine whether redundancy process has been affected in a fair manner. So in the most simplest of terms, I will try and explain this to you in the next few minutes so that should you ever be faced with a redundancy event, this is something that is very clear to your mind. So what does it really mean? Redundancy basically is the intention. What is the intention behind the reason for seeking to declare a specific position redundant? One of the things that you will find that most courts will always ask, particularly if this redundancy process is a challenge in court, is that was the redundancy effect on the basis of a valid or a genuine reason? So for better understanding, just allow me to connect this to the example we gave earlier in the webinar about Mary. So Stella had asked me, in the case of Mary, was the reason that was advanced for her position being declared redundant a genuine and a valid reason? So in this particular case, what we saw was that she did serve the role of a packaging technician, and her role simply was just to pack milk bottles and ensure they were sealed, ensure that they were ready for production. However, given that the company was able to purchase machinery that was able to do this job in half the time and at cheaper the cost, her role specifically was no longer an efficient role within the organization. And what do most businesses look at? Most businesses will always favor efficiency and cost reduction over anything else. So in the case of Mary, what was particularly advanced was that in the process of trying to ensure that the company was saving costs, improving its efficiencies, and looking towards profitability, the machine made more sense as opposed to Mary, because the machine was producing this particular goods at a faster rate. So in this particular scenario, what we see was that a technological advancement in the industry was able to help the company achieve greater returns, but now at the expense of the position that Mary held. And ideally, this is one of the reasons that courts will always look at should these matters become litigious. What was the reason? Why are you seeking to declare Mary redundant? So some of the examples that we have seen through cases we've interacted with, through decided case laws, is that the courts will always look at the business realities. What do I mean by this? In any redundancy event, the court will play the role of an investigator. So look at it in the sense that you're saying you have a genuine and valid reason, but the court wants to know, is it truly a genuine and valid reason? So some of the examples that have come up over time, as we've said, technological changes in the industry, which automate certain roles. We have economic challenges that are brought about by the economy. I think this was very prevalent during the COVID-19 pandemic. And we saw a lot of, particularly the hotel industry that was affected. You saw a lot of companies decide to automate some of, for example, it was as simple as if you wanted to order food, would you have to run all the way to, Java, or could Java have this particular meal delivered to you? So again, automation of roles. And ideally what that meant is that the role of that particular employee did not make economic sense or financial sense to the company at that particular juncture. So what all these examples have in common is that what they're able to demonstrate is a genuine shift in the company's operations. And that is what the law seeks to understand, that there have been genuine reasons as to why the company is shifting its operations and declaring certain positions redundant. Now, what we have seen, and particularly what has come out in most court determinations that we have witnessed over the years, is that a lot of employees, after being declared redundant, will always go and challenge a redundancy process. And one of the reasons they always challenge is on account of what was the intention of my employer declaring me redundant. Now, I'll just give you just a quick example of a call I had with a prospective client just a few days ago, where they told me that they had separated with their particular employer, but then shortly thereafter, the employer proceeded to re-advertise the same role in which they were declared redundant. So then the question that I asked him, and the question that I sought to find out was there a personal motivation or a hidden agenda behind the separation of this particular employee? And that is exactly what the court will want to know. So as an employer, what are the two questions you must answer before the court? Was there an economic or structural justification for the decision to declare a position redundant? At the end of the day, remember, you are not firing an employee, you're not letting go of an employee, you're letting go of a position. And the second question that the court will ask you is the redundancy being used as a mask for a different motive? Are you avoiding a disciplinary process with a particular employee? Are you targeting a specific employee or a specific set of employees under the guise of redundancy? And that's where the issue of transparency becomes very necessary. So as an employer and as a HR practitioner, when you're conducting this process, you have to be able to demonstrate to the employee or the specific set of employees that the redundancy is being fronted for a particular reason. Now, in the case of Mary, I'll go back to the narrative we gave. In the case of Mary, if the company had documented issues with her, let's say, for example, she had issues with her CEO or she had issues with her line manager, and shortly thereafter, her position is declared redundant, what the court will seek to find out is, was her position declared redundant on account of the fact that the role was no longer necessary within the organization? Or was it declared redundant on account of the fact that she had disciplinary issues with her line manager or her employer? And this is the aspect and the considerations that were considered in this case of Agnes Ongadi versus Kenya Electricity Transmission Company, where we did have Agnes, who served as a senior HR executive within the organization. Unfortunately, she had disobeyed a direct order from the CEO of the company and proceeded to hold board meetings in the absence of the CEO. Now, quite obviously, that was not taken lightly and was not taken kindly by the CEO. And there were disciplinary issues that proceeded right after. However, during the course of this disciplinary proceeding, the CEO made a justification to say that this particular role is no longer necessary, therefore we seek to declare it redundant. And that is how Agnes lost her employment at Kenya Electricity Transmission Company. However, what came out later after she sued and took her employer to court, what came out was the fact that despite the employer stating that this was a redundancy, evidence did come out to show that the employer went ahead to re-advertise for her position, but under the guise of a different name. So, she could have been called a HR manager, but now shortly after, the company said, okay, we're now hiring a senior HR executive. So just because you change a name to a position, or just because you try and tamper with the job description of a particular decision, does not necessarily mean that you have effected a valid redundancy. Basically, what do I mean by this? In simple terms, what I'm saying is you cannot fire and thereafter rehire for the same position. And that is what the case of Agnes and Kenya Electricity Transmission Company Limited stated. Mm-hmm. Now, again, yet another very important case law that made significant strides in this particular sector was the fact, the case of Lebo versus Kenya Power. So ideally, what this case was able to demonstrate is that employers and as HR practitioners, you play a managerial role. And because of that, you do have the prerogative to determine the structures and the business operations of your particular company. But if the court were to find out that you instigated a redundancy process with the sole purposes of laying off employees, then ideally what the court will say is that entire process was a sham, and the court will not sanction it. No matter what justifications you're able to give, the court will not align with that narrative. So it is very important to get the intention right. That is what we mean by substantive justification. Lastly, what I will say is, how do we then protect against risk? As employers and as HR practitioners, you will note that redundancy, because of this special type of termination that it is considered under law, it does have the potential to attract liability. Because you can imagine, if you're seeking to declare 50 employees redundant and you get the intention wrong, or you get the procedure wrong, no matter what compensation package you give Mary or you give your employees, at the end of the day, if this matter finds itself to court, over and above what you paid them, you're going to have to pay them compensation on account of an unfair process. So therefore, it is a very expensive mistake, and the reason as to why you must always protect against the risk. So how do you protect against risk? At the end of the day, what I will say is this: as an employer, the obligation to prove a fair redundancy process is in your hands. Okay, so if there is a genuine reason for redundancy, your intent, the intent of the company must always be supported by evidence. So if you're saying it was on account of economic downturn, how are you able to support that particular decisions? Do you have financials? Do you have audited accounts? Do you have strategic decisions or board resolutions that were made by the institution to be able to demonstrate that during this period, the company was experiencing significant losses? Okay, because this is what the court will seek to inquire. As I told you, the court will play an inquisitorial role. So you cannot simply just say, I had a fair reason. The court will want to see your evidence. You must look at it from a risk perspective, meaning that you must always build and document your evidence should this matter ever be challenged in court. And the reason for this is because courts do not just look at the decision of redundancy, but they're keen to find out how and why it was reached. So in the end, what I will say is you have to know your why. It won't matter how well you follow procedure if you don't know your why. If you don't know your why, you're likely to attract significant liability. So I will just hand this over back to Stella so that she can also introduce George, who will take us through procedure. Thank you.
Thank you so much, Ian. That was quite informative. Ian, kindly. Okay. As I stated earlier, thank you so much, Ian, for that particular presentation. And the fact that we're seeing thumbs up and we're seeing people clapping means that it has actually resonated with each one of you. And even hearts, fantastic. But the key takeaways, and it's always important to have key takeaways out of this. Number one, as you stated, it should not be targeted. You should not fire, then rehire, because you also risk the liability of a question of reinstatement. I just want to take you back before we go to redundancy process. Could we just go back to the prior slide, please? Yes. So he stated it should not be targeted, should not fire, then rehire or re-advertise for that same role. It should be genuine, as he's actually correctly put it, and redundancy can be costly. If you remember the first slide that we went to, we were talking about companies that are letting go over 200, 1,000, 16,000 employees. And I'd want to just take you back to the case of Kenya Airways, when they actually rendered 447 employees redundant. And before the matter went to the Court of Appeal, the High Court went and reinstated 447 of those employees that had been declared redundant. Can you imagine how costly that can be? if the court actually finds that you do not have valid reasons or you did not follow due process, that you've let these people go, but then they're being brought back to your organization. Indeed, the Court of Appeal went on to state that the reinstatement was not valid because KQ at the time had valid reasons to let these people go on account of financial doldrums and a decline of their profits. But they were still given, on top of the package that they had, an extra 6 months compensation. And that's for 447 employees. So redundancy is just not a word. It also means that it could cost your bottom line if done wrongly. And that is why this conversation is extremely important. Now, we have understood what substantive justification means. The next question is, so we have a valid reason. What do we do next? Right? We know our why. What do we do next? Please go to the next slide. So redundancy process is now what follows after you have decided as a management or as an organization to declare certain positions and certain services redundant. So the first thing is there must be a notice of intention to declare the employee redundant. And this is just a very reduced way of saying what the process looks like, but we will go through it in depth. The notice of intention to declare the employee redundant is not a termination notice. It's just from the word, it is the intention that I intend to declare your position redundant. There must be genuine and comprehensive consultation with the employee, with the labor office, so that then you try to see, is this issue of redundancy, can it be negated, can be averted, can this employee be redeployed elsewhere, or it is actually something that cannot be avoided. Are there any mitigations? And this comes out in the consultation process, which must also, by the way, be documented. Then, if the only decision is to actually render the employees redundant, then there must be a redundancy notice issued, or this is what we would call the termination notice, and then there's a payment of the terminal benefits. So this is just a shortcut. If you're to take a screenshot, this would actually guide you in terms of your redundancy process. Now, to the next slide, on the notice of intention to declare redundancy. What does the notice of intention to declare redundancy look like? What does it mean? What should it contain? And who does it go to? So first, you must understand that this is a mandatory step. Just saying that I will pay you in lieu of notice, as you've seen many employees who come and they've said, but I paid them in lieu of notice, and therefore that was a notice of intention to declare them redundant. That at the point you're saying you're giving them a notice, you're paying them in lieu of notice, it means that you've already made the decision to terminate them. So the first thing must be this: I must show you that I intend to declare your position redundant. It must be in writing. It cannot be done by way of conversation, by way of WhatsApp. I'm surprised to date that I see organizations issuing such notices just by WhatsApp. It must be a written notice. It just cannot be a conversation. It is issued 1 month prior, meaning that this notice of intention to declare the employee redundant is a 1 month notice, no less. It may not be stated as such in statute, but actually it is stated as such in the International Labour Organization Convention. It must be sent out to the trade union if the employee is unionizable. However, if your employee is not unionizable, like in a law firm, you find that employees are not unionizable, then I will issue that letter to the employee or to the personnel and then copy it to the labor office in your area. Okay, so it no longer is a situation between you and the employee. You must also include the labor office. And why is the labor office involved? It's because it's meant to ensure that employers are not misusing redundancy as a way of letting employees go. They're not using redundancy as a way of a shortcut to terminating employees. So the labor office also must be involved in the consultation process, in the conversation on how to mitigate it, how to redeploy. Then it must have the contents that demonstrate why is this particular position being rendered redundant, who shall be affected, and even the criteria that we have used. And we shall go on to the question of criteria. And then it also states that particular letter that there will be consultations undertaken between the employer and the employee. And that is very important to state. You cannot issue a notice of intention to declare an employee redundant and not actually include the issue of consultation between the employer and the employee. Now, to take us through the next slide on what does consultation look like? So I've issued this notice of intention to declare the employee redundant, right? Then I have stated in my letter that there will be consultations. What does this look like? To take us through that, George Laichana will actually guide the. George, over to you.
Thank you so much, Stella. Just to pick up the conversation on consultation in the redundancy process, we'll just recap on what was mentioned, that redundancy is at no fault of the employee. It is initiated by the employer due to various organization and structural scenarios or reasons, and it's intended to be conducted in good faith and for good reason. For the ambit of good faith, consultation has been the go-to and the minimum requirement, even as elaborated by the International Labour Organization and the Employment Act, and through case law such as the Kenya Airways case, and also the cases that have been stated by my colleagues in the previous slides. And the importance of consultation is to bring to the table all the stakeholders who are to be affected by the redundancy process. So we mentioned that the redundancy process ceases to be between the employer and the employee alone, and now has brought at the table the trade unions for unionizable employees and also the Labor Office to offer oversight and to ensure that the process for the redundancy is carried out in good faith and according to the law. And just to elaborate on the case scenario that we had earlier shared, Mary, in her situation, was not called for consultations. There was no notice issued by the employer that her position is to be declared redundant, and therefore she has no way of knowing what next. She has just been called, told employment, or rather her services are no longer required due to the introduction of a new piece of machinery, and therefore the impact alone will not be felt by the company, but the employee herself. So consultation is a key step in ensuring that good faith and fairness is carried out by the employer or the company. It is not just a matter of ticking a checklist. It is important to ensure that dialogue is undertaken to see whether the company can take up other positions to redeploy this particular employee. Or for instance, Mary, if aside from being a packaging technician, she had the skills that could satisfy the role of a front office, the company would be in a position to take up her services at the front office rather than just terminating her employment, and now she's rendered jobless. Therefore, the purpose of consultation is to ensure that there is little hardship that is endured by the employee, and that the process of the redundancy is conducted in good faith and in a genuine nature. So, just to elaborate further, we have two case laws: the Kenya Union of Domestic Hotels, Educational Institutions, Hospitals, Allied Workers, KUDHEIHA, versus the Nairobi Hospital, and also the Kenya Universities Staff Union versus the Kisii University. In these two situations, the employers were tasked with ensuring that the due process with respect to redundancy is followed. However, they fell short in terms of conducting the consultation. The notice of intended redundancy was issued. However, they did not sit down together with the trade unions, together with the employees, and together with the labor officers to come to consensus on the way forward with respect to the redundancy. Remember, once the notice of intended redundancy is issued, the final decision has not yet been reached to determine or to declare these positions redundant. The consultations will be necessary to ensure that a fair criteria is applied with respect to redundancy or with respect to this position, and to ensure that all avenues or all other alternatives are considered by the employer or the company before declaring a particular position redundant. Therefore, the company or the employer is tasked to engage all the stakeholders, that's the trade union, the labor office, and the employee, to come to a consensus before the redundancy is declared. So just to summarize on why the consultation process is very important, it first of all gives a reasonable opportunity to engage all the stakeholders constructively in order to avert and mitigate the harshness that comes with termination of employment. Because we all understand that losing employment renders you jobless, you are unable to support your family, you're unable to support your basic needs. Therefore, to avert or to minimize the effect of termination or being declared redundant, it's important to engage in this process so that all the stakeholders can reach a consensus or reach alternatives or consider even alternatives to redeploy these particular employees to other positions where they can serve the company further and earn a living. And therefore, it's also to emphasize that redundancy ought to be considered as the last resort. It is not, as my colleague has stated, a predetermined or targeted process. There is no particular employee who is targeted, and redundancy has not yet been determined. So it is only upon or after the consultation that redundancy can be declared, or a company can consider other alternatives and also apply those other alternatives in place of redundancy. And we have seen companies that they issue the notice of intended redundancy, engage in the consultation process, and find a way out of the situation that they are in. They find a way of redeploying those employees who are to be affected in other positions that will serve the company better. And in the end, no one loses their job, and the company continues to run its operations. So that would be the main importance of the consultation process. And I'll just hand it over back to my colleague, who will take us through, once a company has engaged in the consultation process, the only resolution or the only way forward would be to now declare redundancy. So what happens at this point? The company has considered all alternatives, but redundancy is the only avenue to rescue this situation.
Thank you so much for that presentation. Maybe if we just go a slide prior. It's always important, and I deem it important to always look at the key takeaways, because once we've understood the question of substantive justification, we've been told about redundancy process. And it just goes back to the slide that I told you, the notice of intention, the consultations must be genuine. Then you issue the redundancy notices. And George has done a fantastic job in terms of explaining to us what does consultation in redundancy look like. But once that has happened, and indeed there's no other avenue other than to render those employees redundant, Ian will now take us to how do we then calculate what is payable to them. Ian, the floor is yours.
Okay. All right. Thank you, Stella, and thank you, George, for taking us through the procedural requirements as required by the law. Now, we are basically at the tail end. At this particular moment, you've undergone the redundancy process. You have a justifiable reason. You have conducted the process and issued the respective notices. And despite the consultations, despite other efforts to redeploy employees internally, there's no other option but to bring this relationship to an end. So ideally, what the law looks at is that because you're letting this position go, you're basically dissolving this particular position within the company, you must compensate the specific employees who have been affected. Now, generally, redundancies will affect a set of employees. In most organizations, you will see, I think, the main case that we always go back to is the one for Kenya Airways, whereby you have a huge number of employees who are affected by a redundancy. But there could also be cases that also individual employees are affected by a redundancy notice. So once you have issued the final redundancy notice, how does that now look like in terms of compensating this particular employee? Now, one, the law considers that you must pay them their notice pay. What does that mean? If your employees had a notice period in their contracts for a period of 1 month, then the company ought to compensate them the equivalent of 1 month's pay. And this is a strict requirement under the law, because you will realize during this entire period in which you have been consulting with them, they're losing their jobs not because they did something wrong, but just because the company has decided to change the structure. Number two, severance pay. Now, severance pay is often confused with service pay, and I've seen this a lot, particularly in case laws. So there needs to be a big distinction. So severance pay is only payable in redundancy events, and severance pay is not payable in any other form of termination. Now, the difference with severance pay and service pay is that service pay usually comes into play when, as an employer, you have not been remitting the NSSF statutory deductions on behalf of your employee. So that specifically is usually catered for under the contract, or you can be able to look at that through the payslips. But that is not necessarily applicable within a redundancy event unless you are also not contributing those statutory benefits. Severance pay in itself, the way severance pay is calculated is that it is 15 days pay for every completed year of service. So if Mary worked for Maziwa Limited for a period of 10 years, as a termination package, the severance pay would have to include 15 days pay for each single year that she worked at Maziwa Limited during that particular period. Thirdly, you will note that at the point where you are seeking to declare a particular position redundant, an employee would have perhaps already worked for you. Let's say it is September. Maybe they worked for a period of 14 days before the redundancy notices came into play. You would still be expected to compensate them for the days they have worked. So basically, and I think this just generally cuts across, if somebody has worked, they're entitled to pay. Then lastly, of course, is accrued leave days. So the challenge with accrued leave days, and I think this is very important for HR practitioners and employers, is that you must be very careful in terms of how you term your contracts, okay? Accrued, ordinarily, how most employers avoid risk is by ensuring that leave days do not accrue. So what does that mean? If the law gives you a minimum of 21 days leave days, if those leave days are not taken within the year in which they are earned, they are deemed forfeited at the end of that particular year. But if you have a practice within your organization that you allow employees to accrue leave days from one year to the other, you need to be very careful, because if this particular employees do not exhaust their particular leave days in that year of employment, you'll have a situation where somebody is able to accrue 100 leave days. And now imagine this in the context of 10 years. If you've allowed somebody to accrue leave days, over a considerable amount of time, the payouts that you'll end up making at the end will be very expensive, as opposed to a situation or an employer who's thought about it and said, I will not allow accrual of leave days because if you do not take your leave days, they'll be deemed forfeited. So ideally, this is how the compensation package looks for employees who've been let go on account of redundancy. And this generally caters to ensure that these employees are given an affordable compensation package to allow them now to pursue other alternative modes of employment. So ordinarily this, and in the context of Mary that we spoke about, this is what should be entitled to as a final payment. Yes, so just before we go into the conclusion, I would just like to touch briefly just on best practices and basically what our courts have been able to state and basically what companies now need to be aware of. So number one, what we've gone through is that, number one, substantive justification. You must have a valid reason before you effect a redundancy event. So that means you must document it. If you're saying the redundancy is an account of economic downturn or the company is not doing well, you must support that through whether it's board resolutions, whether it's audited accounts. Those issues will definitely come up. You must also avoid disguising a redundancy as a means of poor performance or a disciplinary issue with a particular employee. Secondly, as George has talked about, fair procedure. Okay, so what does this mean? The how in which you conduct the process is very important, meaning that you must give early notification to the employees, you must consult, and you must ensure that the notices are given to the parties that the law contemplates. So if it's a trade union, because an employee was a member of a trade union, that notice has to be given. If it is the labor office, that notice also needs to be given. Thirdly, the objective criteria in terms of selecting these employees. How did you arrive at a particular set of positions? And how did you arrive at a particular set of employees as opposed to others? Then lastly, termination benefits to ensure that legally you ensure that all employees are compensated to the extent in which the law provides. So you will note that some contracts may go ahead and provide for other additional benefits. So if in your company you give bonuses and other benefits, and those are benefits usually accorded to your employees, that would also count as part of the termination and benefit package. Then lastly, and I will not stress this more, you must document everything. Documentation is the difference between you being able to justify a fair termination procedure, a fair redundancy procedure, or the difference between you having your company being subjected to a very expensive payout following a litigation process. So with that, I will hand over back to Stella just to give my concluding remarks. Thank you.
I don't think it's time yet for concluding remarks because there are questions that have been asked. So thank you once again for listening to us. I will cluster the questions based on the fact that some of them ask the same nature of question. The first one that has come up is, can you declare, this is from Wangi Janet, thank you Janet, can you declare redundancy and revamp or build it into a role and re-advertise? I think I can quickly pick that up. No, you cannot, because at the end of the day, then it means that it was just the same role. If you're actually then re-advertising it because you are revamping it, then why did you actually let that employee go in the first place? The court will not consider that as a genuine, apologies for that. Is my video on? Okay. Okay, thank you. Okay. So no, like I stated, an employer cannot lawfully declare a role redundant and then revamp or rebuild it into a similar role or re-advertise it. I mean, unless you can justify that this is a new role that is substantially different from the one that you actually previously declared redundant. Otherwise, then it would amount to unfair termination that is actually masked as redundancy. So it's very important to note that. And in the case of Jane Samba Mukala versus Altukai Lodge, the court said it will always interrogate whether that redundancy was genuine. And if that employee then comes back and says that there's a rehire, only that it has been revamped, then it means that you'll be deemed as having done the process unlawfully. Similarly, we have Maggie, who has stated, is there a period after which you can rehire, maybe if the economic recovers? And to that, I'll say, yes, there is, because you may have let an employee go because of the question of how the economy is actually doing. So it can be a yes and no. But yes, you can rehire only if the circumstances that led to the redundancy have genuinely changed. And there's reasonable time lapse. It cannot be after 2 months you're stating that now you're rehiring. And even if you're rehiring, then the court will ask you, then why didn't you reinstate the employee that was working there if indeed the economy has reversed, right? I'll try and answer them in such a short manner. Then we have a question that I will then refer to Ian. Ian, you're ready for questions? Are piece rate workers entitled to the rights to the rights under redundancy, e.g. severance notice?
Yes, thank you. So I think this one is fairly straightforward. Remember, at the end of the day, if they're clustered as employees, yes, because they fall within the category of employees. If not, they do not fall within the category of the Employment Act. So if you have issued them contracts and you consider them as employees, then yes, they are entitled to the rights under the law, particularly in regards to the terminal benefits under redundancy.
Thank you so much for that. The next question is, can restructuring justify redundancy under Kenyan law? I'll give a very short answer. Yes, it can be used for just as a justification. If it shows that maybe there's an elimination of a role, or there are roles that were conducted by two separate people, maybe it was risk and compliance and operations were two different roles, and now you have merged them into ops and risk roles, or even there's just a realignment or adaptation of new systems. If you're changing your core systems, then maybe it requires less people, or restructuring includes also closing certain branches or locations, then this can be deemed as a genuine reason to render certain positions as unnecessary. Then the next question is, great topic, thank you, TM. Can it be reversed? And if so, by what ways? That is by Hamon Okanga. Hamon, yes, it can be reversed. However, there are two stages that you're looking at reversal. If it has not been concluded, then you can actually proceed to withdraw the notice of intention to declare the person redundant. If then you need to reverse it after you've already issued the notice of redundancy and this person is no longer an employee there, you can actually then seek to reinstate them, so that then you avoid a situation where you're being told that you've gone to hire someone else. So it is reversible if you're actually showing that at the point that you are doing it, there were genuine reasons to believe that there was need to let this person go. Then is there a timeline to rehire? That is, let's say you had gotten a particular technological upgrade and it's no longer working. George, do you want to take that? I can take it. Okay. So is there a timeline to rehire? Like I said, it has to look genuine. Yes, you can rehire, but the question would be, why aren't you reinstating the people that you had actually had before? So then you're showing it has nothing to do with them. The moment you are rehiring someone else because of a technological failure, then it means that you are actually looking to let go of that person previously there. Remember, at the end of the day, we say it should be at no fault of the employee. So if it was at no fault of the employee, then there's no reason to not reinstate them. How do you handle redundancy of a role after an employee has acted in that capacity, but it was declared redundant? I'm not quite sure, Janet. Do you want to take that one? I don't think I've gotten it quite well. Was it an acting capacity? Janet, could you please just clarify it? Was it that role was an acting capacity? I'm not quite clear. I'd be willing to just answer it later. Do you calculate using current salary or the salary that the employee had in the course of employment? I can easily take that. So with severance pay, how you calculate it, it is based on the current salary. Severance pay is based on the employee's most recent and current salary at the time of termination, and not their earlier or not an average salary during the employment. So it is basically severance pay is at the rate of not less than 15 days or half a month's pay of each completed year of service. So if there's a year that was not completed, you may not calculate that, but it's for each each completed year of service. And you do not average it, you look at the most recent salary, and there's caseload towards that. Then the next question is, are there any protections as regards pregnant women? George will take that. Muted my end.
Okay, thank you so much for that question. So with respect to redundancy process, the nature, it cuts across for all employees who are to be affected by the redundancy declaration. Therefore, if an employee is pregnant, the company ought to have the criteria that it requires for before declaring certain positions redundant. Therefore, if this certain employee is pregnant or has any other, let's say, inability let's say inability, then the redundancy process does not discriminate particularly for such employees. However, the company is obligated to consider each and every employee's individual circumstances, aside from their employment performance, or the criteria that the employer seeks to apply with respect to redundancy.
Okay. Then the next question was, if the employee serves still by Beverly, if the employee serves the notice period, does the employee still pay the notice pay? Yes, of course you pay the notice pay. Oh wait, are you saying that after 30 days, then there's a notice of intention to declare the employee redundant, and then there's a notice of redundancy? So are they two separate payments? Is that what you're asking? Or are they considered as one? Just one. Yeah, that's just one. You'll not have to pay extra. So it's the notice of intention to declare the employee redundant, the 30 days, and then the notice of redundancy, which is 30 days. There's no other notice you issue after that, because after the lapse of those 30 days, then the employee is no longer an employee in the organization. When calculating final dues for an employee, is severance taxed separately? Ian, you can take that. Let me just mute.
Yes. So I think as a general payment, it will just be taxed as, for example, how you just tax a normal salary that's paid at the end of the month. You'll still subject it to statutory deductions, because at the end of the day, KRA will still want to know why these payments have been done. So at the end of the day, it's still required to just be taxed and subjected to the ordinary deductions as per the employment contract. Yes.
Okay. Thank you so much for that question. Then there's someone who's asked, speaking of leave days, is it legal to have a clause as an employer that if leave days are not used, they will be forfeited? Ian, you can take that up.
Yes, there's no problem with having such a clause at the end of the day, provided the employee also consents to it. Further to that, you will realize that the Employment Act does give employers authority to sort of structure at given goes how leave can be particularly taken depending on the business requirements. So at the end of the day, because it's earned after every completed year of service, provided you give them the bare minimum, which is the 21 days. If they do not take it, yes, then it is allowed to have them forfeit the same. So the goal is to basically encourage them to go for leave, so that also you reduce potential liability to the company.
Thank you so much. Then the next one is on severance pay. If a staff has worked for 9 years, 10 months, the severance pay will be for only 9 years. Do we consider the 10th month, 10 months worked to better cushion them? Unless you're doing it for purposes of, just appreciating them, but the law only requires for the severance pay to be for the 9 years for every completed year. But if you want to cushion them, why not? That is your discretion. But the minimum threshold is just the completed number of years worked, which would be the 9 years. Advice on restructuring where jobs are changed to realign with new requirements. What process should be followed? I think it is not any different. Whether you're restructuring, as a matter of fact, in one of the cases that we looked at, the court stated that there are people who've called it restructuring, there are people who've called it realignment, there are people who've called it reorganization. It really doesn't matter. The process, as we have just explained it, would be the same. You'd have to have substantive justification and you have to follow the procedure as we have stated it. In case of redundancy and the employer has not been remitting NSSF, is an employee entitled to both severance pay and service pay? And I think Ian did a fantastic job on that. I will just refer it back to him. Ian.
Yes, so you will note that service pay, I mean, at the end of the day, you still have to contribute towards the NSF requirements unless you've opted out under the NSSF Act and you're contributing to a different scheme. But at the end of the day, because it's expected as a statutory remittance, you will have to pay them the service pay entitlement. What you just need to guard against is ensure that you also remit to KRA. Otherwise, if you pay them, they are likely, KRA might flag it if you've not been making those particular remittances, and therefore your company might be targeted for tax obligations. So yes, both of them would be due in the event that you have also not been declaring service pay.
Apologies for that. I don't realize that my mic was off. There's someone who said leave forfeiture does not have any legal anchorage. However, what we have seen is that by contract, if someone takes too long in terms of taking their leave, because you cannot take away someone else's leave, that is actually statutorily provided for. And one of the things that I've seen employees do is actually compel the employee to go on leave. Otherwise, it starts being unbearable for the organization. Then there's someone who's asked, is last in, first out applicable for redundancy in case of outsourced staff contracts ends and the company wants to keep long-serving staff? That, George, you are the one who talked about LIFO.
Able to?
Yes.
Okay, thank you. So when we spoke about the criteria when that the company applies to through the redundancy process, this criteria is normally or usually anchored in the notice of intention to declare redundancy. So this criteria ought to be objective, it should be fair, and it should be transparent. The Employment Act provides that seniority ought to be considered with respect to employees who the company intends, or the positions which a company intends to declare redundant, and that it spells out as a last in, first out. So the last one in the company usually is considered for the first one to be for their position to be declared redundant. So this is important, especially for the fair reason and also the procedural compliance.
Thank you so much. I've seen someone else has answered the question, which criteria, please, LIFO or FIFO? Someone has answered it is actually LIFO, last in, first out. On calculation, should we use the basic salary or inclusive of other allowances? If there were allowances that were actually due and owing at the time they were leaving, then they will be calculated. Sharing recording. So the question of recording, and I've seen this has come up, We will actually, right after this, we will upload it on our YouTube channel. And then when we are sending our thank you messages, we will actually then share, you will actually see the link to the recording. Should you not get the link, Virginia, you could please share just a YouTube link to our YouTube channel on chat. So then it is easy for anyone to actually get it. So that then there are certain questions that have been asked that have already been answered. Then still on the question of LIFO, I think that has been dealt with. Samuel Kamau, you can look at the presentation that was actually dealt with by George. If an employment contract has a 3 months notice period for termination, can an employer only give 1 month redundant? No, you cannot give that. You actually have to terminate based also on the contract. If it was meant to be, so at the point of notice of redundancy, that notice will be based on the contractual term. If it was 30 days, it's 30 days. If it was 3 months, it's 3 months. That is what is applicable. How severance pay calculated? That has already been covered in our presentation and it will be seen on our YouTube channel. Ian did cover that. Can an employer deduct an SSF from severance? Ian, you had talked about service and severance pay. You cannot deduct it from, because anyway, answer it, Ian.
Yeah. So I think they're very distinct, and I think that's the distinction that needs to be made. Severance pay is a payment that is classified on its own according to the Employment Act. Service pay basically will be deducted out of now the notice pay, because at the end of the day, it's as if you're paying a salary. So you deduct the statutory deductions out of the salary, but legally, as per the Employment Act, severance pay is looked at a distinct form of payment.
Then when calculating severance pay, do you use gross or net pay? You use gross pay because it's subject to pay. I can see the question of leave days. That someone said forfeiting leave days is not in the Employment Act. Yes, it is not in the Employment Act, but as a matter of practice, people have included it in their contracts as a means of controlling the number of leave days there. I do agree with that. It is not in the Employment Act. We have a few court cases that have described forfeiture of leave days, and I agree. The court has stated that the employer's obligation is to ensure all employees proceed on leave. Completely what I stated, that it is the role of it's the role of the employer to ensure that you do not have an employee who has too many leave days and to actually compel them to go on leave so that then it does not become unsustainable. We do a lot of redundancy in cases where we are unable to redeploy for our stewards, especially when some projects come to an end. As for our strategic initiative, the company intends to take up, is it diversity? I'm not quite sure whether that's a DEI for inclusion, meaning we'll take up employees who are differently enabled. What's your take on that? I've not understood this question on how it ties, Wamboi, I've not understood how it ties to the question of redundancy. Please re-ask it. In terms of now, what is our take on what exactly? On you taking up employees who are differently enabled, or is your question on the question of redeployment and when projects come to an end? And I know this particularly for companies that deal with cleaning companies or casual companies that deal with casuals, you find that contracts are tied to the contract that you have with the person that you're outsourcing to. But just what is our take on what exactly? That's not quite clear to me. I think the question of leave has been dealt with. Again, the question of leave. Ian, again, on leave days, I would like Ian to elaborate more based on Section 28 of the Employment Act, which gives up to 18 months to utilize the accrued but unutilized leave days. Ian, over to you.
Thank you. So again, what I would say about this is that generally, so with respect to leave is earned for every completed year of service. You're able to earn 21 leave days, and that is the minimum required by law. But you will also realize that if you look at that particular section, that there are instances, and there have been instances whereby, depending on, for example, let's say like the workload or how the organization is structured, you can enter into an arrangement whereby you agree with your employer that maybe if you're unable to go on leave during a certain period, maybe you guys are undergoing an audit and your services are required, then you can agree with your employer that you will then structure your leave days to be taken at a certain period. So at the end of the day, leave is still an entitlement, and you have to remember that as an employee, you are entitled to leave, and you are entitled to go to leave, and an employer cannot deny you the right to go to leave. What I was saying is that there are means to agree in terms of structure on how leave days can be taken over a considerable period of time. However, the law does not prevent an employer from entering into a contract with an employee and telling them that if you do not take up your leave days within a certain period, the same are deemed forfeited. So you're encouraged to go and leave, but for the company, it can also be unsustainable to the extent that you're allowed to hold on to leave days for 3 or 5 years just because you're building up on your leave days.
Agreed. And I see we are doing badly on time, so I'll just take up 3 questions. But please do feel free to engage us. Virginia will share our email address. Virginia, please share our info email. We consistently, by the way, as a law firm, do articles on the question of labor-related matters, employment matters. So please, if you would like to be a part of our mailing list, you can just email us on info@mmw.legal. Virginia is typing it, and you'll be included as part of our mailing list when we have the employment corner, which is issued out every month. And then on a week, every 2 weeks, we issue something related to labor matters. Just for the benefit of time, because it still is a working day. There's someone who's asked, on the question of notice to the labor officer, is it illegal if I don't give notice to the labor officer and follow other processes? Yes, because the law requires you to actually do it. So long as the law requires it, not doing it therefore makes it unlawful. I do not know which question to take and which one to drop. Please forgive me for this. Our email has been shared. We are very tight on time because we're told to have completed this particular session by 10:30 sharp. My sincere apologies if there are questions that have not answered. Is there any one that is very unique and has not been dealt with? Okay, very well. So like I stated earlier, we will upload this particular video to our YouTube channel. We've shared our info@mmw.legal. If you want to be part of our newsletter that receives, and you want to be an employer or a HR practitioner or an employee who consistently is on the know on not just what the law is, but what the court is interpreting the law to be. And I know a lot of HR practitioners are very, very good when it comes to understanding the Employment Act. But then when you go to court, you find that how the court interpreted it and how you interpreted it are completely at odds or are parallel. So what we then do is actually make sure that you're consistently in the know. And an empowered HR person is an empowered organization. And there's something that someone stated here, that they talked about having the intelligence. That was Maureen Munguti, who said that I reckon the need to apply humane intelligence to understand that there are some gaps that may not be the employee's fault. My HR reference and background checks will be intelligent going forward, because sometimes you give so much power to managers or companies that may not want to follow the law. And this training is to ensure that you do not find yourself as a witness on a stand and you're unable to explain why an employee was actually rendered redundant and rehired, or why process was not followed, and so on and so forth. So thank you so much for engaging us. I also noticed that the question of how leave is handled is extremely important. One of the things that, Virginia, we need to do is actually do an article on leave, what the law requires, also looking at the regulations, what can it be dealt with from a contract perspective, can there be forfeiture? And then also looking at case law, so that then we are able to share the question of leave, because it's not necessarily a webinar issue. We can actually just do an article and empower our listeners on the question of leave days. So if you'd be interested in that, again, send us an email on info@mmw.legal, and we will immediately actually share, put you on our mailing list. Also, Virginia has shared our WhatsApp number, so that then you're actually added to that. If sending an email is too cumbersome for you, you can actually send us a WhatsApp email for your email to be added. Thank you so much, ladies and gentlemen. Thank you so much for Virginia and Stephen Juguna, who have been working behind the scenes. I think they can just wave. They are the ones who have done this particular presentation and made sure that the technological end and the presentation looks beautiful. Thank you, Ian. Thank you, George, for such a wonderful presentation. The time has, a lot of time has gone towards making sure that you guys enjoy this. And thank you to our very lovely audience that have kept us on our toes for the last 30 minutes, answering and asking questions. Yeah, thank you so much for organizing this. It shows that there was a need for this. Ladies and gentlemen, you can log off as and when you want to. Have a great day ahead. And remember, always follow the law. Should you have questions, reach out to us. Bye.